in your deliberations. When you're done, you can keep those, leave them in the jury room, discard them, whatever you want to do. When you're arrested, confined, indicted for, or otherwise charged with the offense gives rise to no inference of guilt at her trial. The law does not require a defendant to prove her innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after a careful and impartial consideration of all the evidence in the case. The state has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. If the prosecution fails to do so, you must acquit the defendant and say by your verdict, not guilty. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt, after considering all the evidence before you and these instructions, then you will acquit the defendant and say by your verdict, not guilty. 4. You are the exclusive judges of the facts proven, of the credibility of the witnesses, and of the weight to be given to the testimony, but you're bound to receive and be governed by the law from the court as contained in this charge. 5. You can only consider facts and circumstances in evidence. You must not consider or receive from any source facts or circumstances that have not been introduced by testimony before you. It is only from the witness stand that the jury is permitted to receive evidence regarding the case. It is not proper for any juror to discuss or to mention to any other juror anything which the juror may have heard or read on the outside about the case. If any juror, after being chosen on the jury, should discover that he or she has any outside information or has heard anything concerning the case, then the juror should not impart that information to any other juror, nor should the juror consider that information in arriving at a verdict. 6. You should not question the bailiff concerning the testimony or the law of the case, nor should you discuss the case in her presence. If you have any questions, you should reduce them to writing, have them signed by your presiding juror, and present them to the court. Number 7, you are instructed that you are not to allow yourselves to be influenced in any degree whatsoever by what you may think or surmise the opinion of the court to be. The court has no right by any word or act to indicate any opinion respecting any matter of fact in this case. If you have observed anything which you may have interpreted as the court's opinion upon any matter of fact in the case, you must wholly disregard it. 8. You are instructed that any statements of counsel made during the course of a trial or during argument that are not supported by the evidence, or statements of law made by counsel that are not in harmony with the law as stated to you by the court in these instructions, are to be wholly disregarded. 9. Do not let bias, prejudice, sympathy, resentment, or any such emotion play any part in your deliberations. 10.